Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call every other Thursday. I'll go over the questions that have been posted and that I have marked as frequently asked questions first. Then I'll go over the questions that are routine questions also posted, and we'll do follow-ups as we go along. If time permits, we will then do new questions. Okay, that said, let's get started. Did I mention today is March 24th? I guess not. Let's just tag that down. Today is March 24th, 2016. Um, and we are getting started now. Okay, first question, which is a frequently asked question, is a 221G administrative problem with visa stamping. So changed status to H-4 while she was in USA. I have a PhD in microbiology. Okay, husband qualified for interview, waiver, got the visa stamped, um, while she is stuck with the 221G slip. So the H4 derivative is stuck with a 221G, which basically, what is a 221G? It is essentially an extremely uninformative provision. Basically means your documentation is insufficient for grant of the visa. Now, a 221G could be a very minor matter, could be resolved within a couple of days, and it could also be something that takes months to process. I know people who were stuck for over a year. In fact, one of the cases I know has been stuck since last October. So it's time now to file for the next quota, and that guy is still stuck with his 221G a year later. So that can happen. The questions that AGAR 2003 has are: the embassy and the US travel docs and travelstate.gov all say the same thing. Wait for 60 days. Um, and then ask questions if I don't hear back. What is the reason for my case to be put under admin processing? Is it because I have a PhD in microbiology? It can be. It can be. Okay. The reasons for administrative processing are as vague as administrative processing itself. It's so difficult to find out why exactly you've been put in admin processing. But there are some checks called Visa Mentis, Visa Donkey, these checks that have to be done when any technology that you have been working with is potentially a technology that can be used as a weapon. So that pretty much is everything. I mean, in today's world, any scientific knowledge can be put pretty much to weaponized uses. So it creates a problem for people who are in scientific fields, and professors and researchers often run into these difficulties. So to answer that question, is it because I have a degree in microbiology? The answer is maybe. What should I do now? Husband has a full-time job, so he went back. I am stuck with a 16-month-old child who's a US citizen who's getting crazier by day in this hot climate in New Delhi. You know what you should do? Have your husband contact the local congressman's office. Tell them to please help because there are humanitarian considerations here, and this child is having a hard time with the heat. And as time progresses, it's only going to get warmer and warmer. Can you please schedule us for a follow-up interview if it's needed? There is really no reason to be holding back an H-4 holder. So you can try having your husband contact the congressman's office. They're usually good about trying to help. Will they be effective? I don't know. That depends on the kind of 212G, 221G you have being investigated. So I don't know what the reason for that is. Travel.state.gov describes timelines within a week. There's no tracking on the applicant's average time. Isn't there a Right to Information Act in the United States? Oh, well, ma'am, that's a relatively innocent question because there is a certain amount of transparency that has slowly crept into the system, but by no means are we completely transparent. Many times we don't know. Some of it we can understand. It is because the government needs a little bit of elbow room to finish their investigations, but some of them is just bad management. Okay. Uh, what should I do? And I already explained that to you. Can we have a tracker on immigration.com so that everybody can add their case and get approximate processing? Sure. Just go ahead and send me an email to help@immigration.com. Tell me what you need, and we'll be happy to set something up for everyone if that's what you guys need. Email is help@immigration.com. Okay. Anyone has a question on 221G, press *5 on your phone. No new questions, only a question of 221G, *5. Okay, I don't see any questions. Let's go on to the next frequently asked question, just to remind people who have logged in lately. I'm just doing the frequently asked questions first, then I'll do other posted questions, then new questions, if time permits. Now, this is another, Rakesh Mishra has asked a question, which is also a frequently asked question. Look, my visa is expiring next week. My H-1, can I enter the United States? And the answer is sure, sure. Even if you have 1 day left on your visa, you are allowed to enter the United States. There could be questions about how long you are going to stay, how are you going to stay. If the employer has already filed an extension or is in the process of filing the extension, that question is answered brilliantly and completely. Nevertheless, you are allowed to enter the United States under the law, even if you have 1 day remaining on your visa stamping. How long will the CBP let you come in for depends upon the circumstances of your particular case. If you already have an H-1 approved and you've got it to, let's say, 6th June, and you enter on 5th May, they should give you till 6th June at least on your I-94. So that pretty much is the way it goes. You have the right to arrive at the airport. How long you can stay depends upon the particular case and the particular visa. If you have an H-1 visa, especially where an H-1B extension is already filed or in the process of being filed or will be filed when you enter, you shouldn't have any problem coming into the United States even with 1 day remaining. Anybody has any questions, press *5. No new questions, only questions on a visa about to expire and entering the United States. Okay, I don't see any questions. Let me expand the screen. Okay, I don't see any questions. Let me go on to the next frequently asked question. These are questions that I mark as something that people are asking time and again, and then our team transcribes them and puts them in our frequently asked questions. So we have a frequently asked questions section, which is constantly expanding. Okay, so another frequently asked question is travel while H-1 change of status is pending. So somebody, Jairam, is asking about spouse who's on H-4 and wants to apply for her H-1. Is it advisable to travel to India while her H-1B is in progress? Okay, well, remember, and I've said this on several occasions before, I've said it that, guys, whenever you are on one status and you apply for another status, like from F1 to H1, from H1 to H4, from tourist visa to student visa, anytime you have a situation where you are going from one status to another, your application with the government has two requests implicitly contained in your application. What is that request? One request is find me eligible for the status I'm asking for. So when I go from H4 to H1, I tell the government, Mr. USCIS, can you please hold me to be eligible to receive H1? And if they say yes, then we go on to the next step. Next step is actual change of status. So not only do I want to be held eligible for H1, I want you to then change my status to H1. So there are two applications within that one application when you file for going from one status to another. One is the determination, and the other one is the change. When you travel outside USA, generically speaking, there can be exceptions. Generically and generally speaking, your application for determination is not invalid, but your change of status is invalid. So what does that do? Let's say I'm on H4, like Jairam's wife is, and they file for my H1 change of status. I travel to India or Switzerland or Malaysia, wherever I want to go, and I come back. Government will give me my H1 if it is approved, but they won't give me status change from H4 to H1. I'm still on H1. My H1 is I'm sorry, I'm still on H4. My H1 is approved, but only the determination has been issued that I'm entitled to an H1. Now I have two choices. Either I can apply for change of status from H4 to H1, because by traveling out I abandoned that part. I didn't abandon my determination request, but I abandoned my change of status. Uh, the second option is to go to a consulate and get a visa stamping and come back. Okay, so if she travels, she's going to have to do one of these two things when she comes back. Okay, she won't have to wait outside the United States if she doesn't want to. She can come back on H4. Will there be any implications if I travel outside? No, if you're an H1 holder and you're going for a short duration, a week or 2 weeks, I don't see any problem, no implications. Okay, any questions on this topic? No new topics. *5. Any questions on this topic? Okay, no hands. There is one. Okay, let's go to that one hand.
Hi, Rajeev.
Hello, how are you, sir? Hello?
So,
Go ahead.
hi, Rajeev. You able to hear me?
Yes, I can. Sorry, I'm a little flustered because they have changed our dashboard. Some of the GUI is so odd, it's kind of, I'm finding it difficult to find some of the commands. So excuse me, it might take me a day or two to get used to it. I can hear you fine. Go ahead, please.
Okay. So now, if we file a COS, like the employer file a COS for my spouse, then will I be able to? I mean, will she be able to travel, or you advise not to travel when the COS is filed?
Well, the problem is it's not that she's barred from traveling. By traveling, she's abandoning her change of status request.
Yeah. So I mean, actually, we want to avoid a situation of her uh, uh, to go to a visa interview again. So that's the reason I want. I mean, I want to avoid that situation. That's the reason.
Let me suggest this to you. Let me suggest that you file the H1. There's no guarantee she's gonna go through the lottery, right? She's subject to the quota, right?
Yeah.
Okay. If she's
Yes.
subject to the quota, there's no guarantee she's gonna get picked up. So if I were you, what I would do is I would file the H1. Then I would wait till May, June until I find out whether the spouse has been picked up or not in the lottery. If she's been picked up, then I would say let's not have her travel. Let's just slide on to the H1 from October onwards. Somewhere along the line, if you want to go get her visa stamping done in Canada or Mexico, one of these nearby countries, you can try that. Otherwise, if she doesn't get picked up in the lottery, then she can travel on her H4. There's no problem, right?
Yes. So I was just thinking, like, if it is picked up, then I mean, should we prefer to travel or just
No, see,
wait?
if you want to avoid visa stamping, then obviously you shouldn't travel.
Okay.
Okay.
Yeah, I get that.
Good luck, sir. Okay. There is another one. I think we are done.
So, yeah, thank you, sir.
Okay, bye-bye. All right. Let's see. I think we have one more frequently asked question. Yes. Okay, this is also coming up rather frequently. Does H4, oh, this is bad English, sorry. Does H-4 EAD have to be applied? Not has, there's a typo. Does H-4 EAD have to be applied again if H-1 changes jobs? Okay, so my spouse is on H-4, I'm on H-1. If I change jobs, do I have to get her EAD again? The answer is of course not. The only time you have to worry is if you fall out of status. Then there's all kinds of issues that arise. But as long as you are maintaining status, every time you change jobs, her H-4 and H-4 EAD is good. Until her H-4 and EAD are about to expire, there's nothing else you've got to do. Can she continue working? Of course. And you don't have to change H-4s every time you change H-1s. Okay, any question on this issue? Press *5 on your phone. No new questions, *5. Any question on this issue? Okay, now I will answer the questions in the order posted. And if time permits, we will do new questions. Uttam is from Nepal and master's graduate from US University. 6th year of H-1B. H-1B is expiring September 31st of this year. Green card is going on. I-140, premium processing, da da da. So the situation is, I and my wife both have applied for TPS because of the earthquake in Nepal. You had temporary protected status. She's on H-1B. H-1B is expiring in December. And your TPS is good till December 24th. So question is, can I change my status to H-1B dependent? So this is the wife asking, I guess. Can I change my status to H-1B dependent on my husband while my I-45 case is pending? You can. You can. Could TPS EAD be my option? As far as I know, there is no problem with having 485 and TPS EAD going on at the same time. I am not aware of any reason that you shouldn't be able to, but please double check. We are very heavily focused on business and professional immigration investments and H-1s and L-1s and E-visas. So my work has been very incidentally involved with TPSs. So double check it, but I think all of this is possible. You can convert to H-4. TPS EAD should be an option as well. Okay. Any questions on this issue, *5? Any follow-up questions on this? Press *5. Okay. Go ahead, please. I can hear you.
Hi, this is Uttam. Thanks for answering that question. So it appears that I have some options based on your answer. And
yeah,
I'm
let me
Uttamji,
Uttamji, let me add this. To the best of my knowledge, TPS always gives you more rights. It doesn't take away any existing rights. That's the way I remember it. That TPS will always. Yeah, go ahead.
What I also heard was not from many people, including attorney, that if you are an H-1B and try to use TPS EAD for the second job or any other concurrently, then you are violating H-1B.
Right. No, that I understand. That I can understand. I have no problem with that.
So when I-485 is pending, then I'm no longer on H-1B. It's a different case, different status pending. So it's TPS is option possible.
Yeah, that's a different situation. That's a different situation.
So besides that, this timeline I mentioned, August 31st, 2016, H-1B expiring and always time consuming during LC approval and I-140, I-484. My question is, do I have enough time here before I make these all options available, or should I just wait and watch?
Well, listen, you filed your labor cert on December 18th of last year. Now, to your knowledge, has there been any request for an audit? It's a little early for that.
No.
Okay.
No.
So really, Uttamji, some variables depend upon whether or not you get audited. If you don't get audited, you could have potentially by June, July, or even August, you should have your around August, you should have your labor cert as you have anticipated. But if you go into audit, then there is no telling how long it will take. So even if we take the worst case scenario, from December 17th of this year, you are entitled to extension of your H-1, no matter what, because that would be 1 year anniversary of your green card filing, right?
I didn't follow that last part.
Okay. Um, do you know that you can get your H-1 extension once your perm has been in process for 1 year?
No, that's well, that has to be done before 365 days prior on your last year, right?
No,
The
no,
file extension.
you are misinformed. Okay. Let me take your example. Okay. So you understand that from June 17th, 2016, um,
Yes.
no, I'm sorry, from December 17th, 2016, you'll be entitled to 1 year H-1 extension because of your perm. You understand that?
Oh, okay. So I thought I was under the impression that I have to file my I-485 prior 365 days of my H-1 expiration.
No,
That is not the
no,
correct statement, though? Oh,
there's no such rule. Okay. So
oh, okay.
when does your current H-1 expire, sir?
The same date, September 31st, 2016.
So even in the worst case scenario, you will not have work authorization from September to December. That's it.
Yes.
So you could do the shake in Nepal, I guess. It's awful. I know it's still going on. I have friends from Nepal. They're saying it's still things are still shaking. So if you wanted to go back to Nepal for a couple of months, you could do that. If you wanted to try to convert to a tourist visa for a couple of months, the point is December 17th onwards, you'll be back on H-1 if it has been applied for. So it's really not that big a deal.
Yeah.
Okay.
Yes. So just one more and repeat of your statement that just to clarify that I am still eligible to 1 year extension on my H-1B. Is that right statement?
You'll be entitled
Once I
once you have
yes.
that 1 year anniversary reached, which is December 17th, 2015. Your
December
perm,
17th.
your perm was filed on December 18th. I'm sorry.
Yes.
Yeah, December 18th, 2015. So 1 year from
Yes.
that is December 17th, 2016. That date onwards,
So that day,
yeah,
yes.
that day onwards, you are entitled to 1 year H-1 extension.
Oh, that is how it works. Okay, so I had the other way impression. I had to prior. Okay, I think I'm clear now. Very
Yeah,
clear. And
let me add one more sentence to give you better context. Before the year 2005, the law used to be that in order for you to get H-1 extensions beyond 6 years, your there should be no gap in your H-1 status. That is no longer the law. So even if there's a 2 month gap, no problem.
oh, okay.
Okay?
Okay, good. Okay, so September to December, that's 4 months gap, so I don't have problem. I can either way, I can get my H-1 extended even if I stay unemployed for 4 months while waiting.
Exactly. Exactly.
Perfect. That's
Okay.
wonderful. This is very informative. Thank you, Rajitji.
You're
I
welcome.
appreciate it.
Good luck.
Bye.
Okay. Let's go on to the next question. Um, this is from Subbu Rutgers. On H-4 studying at Rutgers, would like to switch to F-1. So should I go to Canada, India? Advantages or disadvantages? See, you can go to any country, okay? But the problem is, it is then up to the consulate. Many consulates are not fussy about it. Like many people I know have gone to Canada, they've gotten their student visa. But sometimes the consulates say, look, Since you are from India, we don't know what your intention is. Only the Indian consulate can better judge your intention. So they could say, go to your home country. And that means of course, you'll be able to enter back using your H-4 if you wanted and then plan a trip to India. But that is the only worst case scenario. I mean, I personally don't see why you should not apply in a third country. I would apply from Canada and see how it shakes. A follow-up question on this, star 5. Any follow-up question on this, star 5? No new questions yet, star 5. Okay, let's go on to the next question. Oh, there is one. 1 second. Select. Go ahead, please. New York, go ahead. Yeah.
Hello, Rajiv.
Yes, sir.
Sir, I have a question on my status. So
No, no, hang on,
if
hang
there
on,
is new
hang on,
questions.
hang on. No new questions. That's the end of the call. So just
Okay.
sit tight. Sit tight, guys. Okay. This GUI is driving me nuts. They have changed the, like I said, they've changed the dashboard. I have to struggle to find the controls. Okay. Next one is VSS 123. When somebody says VSS, the first thing, I've become a computer geek. Volume shadow service. VSS 123 says my previous H-1B expired on November 30th, 2016. Renewal receipt date is August 2016. How long can I work? 240 days. 240 days from the date your I-94 expires. Okay. So you can continue working up until 240 days from the date your I-94 expires or until a decision is made, whichever is earlier. So if a decision is made in 100 days and you get an extension, great, now you are working on an extension. If you get a denial, you can no longer work. Okay. At which point do I need to apply for premium processing rather than waiting? That's your patience, whatever your patience level is. We could travel out of USA for any emergency or home country prior to the approval of the renewal. Yeah, the answer is if you do that, you will not be able to come in without getting an approval, getting a visa stamping, and then coming back in. Once your H-1 has expired, you are in authorized period of stay. If you travel during that time, you've got to stay outside, okay, until the next H-1 is approved. So star 5, if you have a follow-up question on this, press star 5 on your phone. No new questions. Star 5 for follow-up. Okay. Nothing yet. All right. Let's go on to Arshad's question. Arshad's question is, when should my family apply for citizenship? 5 years completing 25th August 2016. Look, if you meet the stay requirements and the domicile requirements, you've been living in that state for at least 90 days, you can apply 90 days ahead of the 5th year. Okay. So if your 5 years are completing on 25th August, count back 90 days from that, which brings you August to June, July to June, June to May. So about May 26th or 27th, something like that. So you can apply for naturalization 90 days ahead of your 5th anniversary if you meet all other requirements. Star 5 if you have a question. Press star 5 on this. No new questions, please. Okay. Jairam 2016 is an employee working full-time on H-1B for a US company. 6th year of H-1B, 10 months left on my visa. 1 month of recapture is possible. PERM was applied in July 2015. They got a denial. So no error from their end. They would be able to file an appeal. Well, the problem in these cases is not that whether or not you're going to win. If the appeal is to BALCA, which is for denial of a PERM case, it takes 3.5 years. I had a very, very strong case for an appeal, and I'll give you that example as a roadmap to something you can do. So I had no choice but to file an appeal because he was running out of his H1 just like you are. So once the appeal is pending and your green card has been going on for 1 year, you are entitled to 1 year H1 extension. Your lawyers can time it so a second case is prepared. Somewhere along the line, they'll have to withdraw the appeal when you have enough time on your H1 and refile the PERM. Otherwise, it will take too long. Unfortunately, only 1 to 2% appeals are successful. We've had some successful appeals, but appeals are usually a method or a fallback as a part of the overall case strategy to continue to get your H1 extensions. So that is something you should think about. So even if the chances of decision were great, it's going to take 3.5 years. You can't wait that long. Can we do H1 transfer in 7th or 8th year of H1B visa? Yes, you can. You can do transfers in 9th, 10th, 11th, 12th year, any year. Okay. *5 if you have a question. *5 on your phone if you have a question. Okay. Let's go to you. Yeah, go ahead, please. Yes, sir. Go ahead, sir.
So the reason I gave for the denial, right, saying that the PERM application did not explicitly mention that I have passed the assessment. So, I mean, what are the chances of success in this type of scenarios? Like,
look, this
in the request for reconsideration?
This issue has been addressed by the government, and there's a whole lot of cases on this. Your lawyer should be able to share them with you. They have a cutoff date. If the application was filed before that date, they will not deny the case. Especially if you file a motion to reconsider under government error Q, you can ask your lawyers what that means. It's a long discussion. But that's definitely something that could work out if your application was filed before Department of Labor came out with a frequently asked question that said, this is how we want you to handle the inclusion of the beneficiary's qualifications. You have to be able to prove to us from the 9089 itself that the beneficiary is qualified. So they issued a frequently asked question. And before that, if your application was filed, they will accept it. Now, I don't remember this issue in detail. Maybe Balka has approved other cases even past that date. But so generally speaking, you have a very good case if your PERM was filed before the fact came out. You have an uncertain case. I'll have to look at the law and what Balka has been saying if your PERM was filed after that date. Okay.
Okay.
I'm sorry if I confused you, but this is as simple as I can make it.
Yeah, no, I get that actually. And I have one other question on this. Say, like, my employer, like, he decides to file appeal and at the same time file a new PERM in parallel to the appeal from a different location or different role. So, will that cause any complications, or
that can be done, but I don't remember exactly what the Department of Labor's last advice on this was. But I have not been in this situation for a long time. When we had to do a repeat filing, at one point, I think it was a few years ago, I checked with the Department of Labor, and they told me if it is the same employer and the same employee name, we will deny the application. Then you have to file a motion to reconsider and justify how these are two different jobs. I heard after that they had changed their process, but I don't remember exactly what their process now is. So look into that. But under the law, it certainly is possible to have two cases going for the same individual, for the same company, if they are either a different location or a different job. Okay?
Okay. And yeah, and regarding the last question, that can we do H1 transfer in 7th or 8th year of H1B visa?
I already answered that question, and the answer is yes.
Yeah. Yes, but actually I have just one follow-up question on that. So if my employer, or like if I get another employer get file a labor for me like maybe in 7th or 8th year, and by if by luck like if that gets approved, and will I be able to get an extension on based on the other labor which is
Yeah,
filed after 6 years?
as long as, yes, even if the labor is filed after. Look, I am going to have to cut you short because there's a bunch of people waiting. So
Okay.
I will answer this as your last question. And the answer to your question is, your question right now is, I'm on my 9th year of H1. I've applied for another labor cert. Can I get a 10th or 11th year based upon the labor cert I filed in my 8th or 9th year? The answer is yes. There's no requirement
Okay.
that you can only get extensions that you file in the first 6 years. Your
Okay, yeah, that's all I had actually. Yeah.
Good luck.
Thank you very much,
Oh,
Ali.
you're welcome. You're welcome. Always a pleasure. Okay, we're done with this one. What a stupid GUI, honest to God. I could design a better graphical user interface than them, obviously. Okay, I think users actually do better with making their own graphical user interface. Anyhow, US Immigration Help says, I have an approved I-140 from employer A. I've gone to employer B. They filed my H-1B transfer with the approved I-140 from A. My H-1B was approved only for 1 year. They say they cannot guarantee PERM filing. What are the odds of my situation? Please advise me with some safe movement. See, the problem is, look, if you can, there are two things that can help you. See, one thing is, and I have to, normally I don't have these little rays of sunshine in all cases, but in your case, there are two possibilities which would really help you. One is, if you can convince your old employer not to revoke your I-140, at least for a few months, and I'll explain to you why that is important, you should be able to, without any problem, you can keep getting H1 extensions as long as you've got the H1. Next one should be 3 years. The only reason you would get 1 year is either the company didn't ask for 3 years or they were not able to prove that they had worked for 3 years. Now, if you can leave it open for a few months, the new regulations, which are under consideration right now, might come out tomorrow, might come out next month. They're quite close to being completed. The new regulations would allow somebody whose I-140 was revoked 180 days after its approval to use that I-140 even though it is revoked to keep getting H1 extensions, which is a great benefit. That means you never have to worry about H1 extensions, people withdrawing your I-140. You could go to any employer and keep getting H1 extensions because one, your I-140 was approved, and then two, it was revoked after 180 days of approval. So you really have to just cross that 180-day borderline and then also wait for the new regulations. If the I-140 is not revoked, you can keep using that. If the new regulations come out, you have nothing to worry about. Okay, so follow-ups on this, star 5. Follow-ups on this, press star 5. No new questions. Okay. Cross-chargeability. International student on F1 visa, Vietnamese citizen, born in Vietnam. Boyfriend is working for a company in US under H-1B, applied for green card, got I-140 approved. He's India born. Your understanding is correct. If you get married, you can both file under Vietnam quota An. So this is Antran. If you get married, you don't have to leave the United States. It's quite easy. All you do is you file your 485 after marriage. Both of you file your 485 and the I-140 together, and you indicate on the case this is a cross-chargeability case. and your certificate of birth is attached, you're a Vietnamese born person, and he takes advantage of that. It's not complicated at all. We do it all the time. Okay. Press *5 if you have a follow-up question. *5. Okay. Let's go on to the next question. Mohit Jain says, my 6 years is over, November 2015. I'm in India. Current employer filed I-140, which got approved last week while I'm in India, but they don't have any positions on site for the next 1-2 years. Can I apply for a new cap exempt H-1B through another employer? Yes, you can. Because you left in November 2015, you could, even if you took remainder option, you could get 3 years of H1 anyway. You should be exempt from the quota, I guess. There's a little complication here, but my guess is it's certainly worth looking into. You should be quota exempt. That, I think, was the way it would work. And you can apply through any employer. The only problem is, Mahji, just remember this. When your green card is going through one employer and you change employers, your I-140 may not be good for 485 any longer, because government could say that while you were gone, the job ceased to exist. It isn't like that job was redistributed amongst the existing workforce. And if the job ceases to exist even for 1 day, that I-140 cannot proceed to 485. But until that I-140 is revoked, it can be used for extensions through any employer as long as it is alive. I hope that answers your question. *5 if you have a follow-up question. By the way, An, I just saw that you are on the phone. I don't know if you heard me. If you have a question about cross-chargeability, press *5. I just saw you on my dashboard. An, if you have a question, press *5. Okay, you don't. Mohiji doesn't. Let's go on to the next question. I received my green card under outstanding researcher EB1B category. Due to some internal problems, I would like to change my job immediately. See, you've got your approval. Now, on the date you got your approval, you had the intention to continue working indefinitely. Your employer intended to have you continue to work there indefinitely. Some unexpected changes happened. I think you are okay as long as you can document, like a letter from the employer, some memos showing how this was unexpected and came to be. It's a very aggressive green card, but I think you can defend it by showing that on the date the green card was approved, your intention was of indefinite employment in that role. 2 days later it changed, but it wasn't something you had pre-planned. I think it will work. You don't have to inform USCIS. And AC21 is not necessary, not applicable. Okay, *5 if you have a follow-up question. *5. Okay, so I've given you my opinion. Let's go on to the next one. Sudhakar Alapati. Oh, this is a long one. I'll start from the bottom up. That's probably easier. Okay, or you filed your OPT with the wrong filing fees. So that's an easy one to answer. Okay, so now it's gone. There's not much you can do. If you're out of that time period during which you're required to apply for OPT, you can't do it again. The only options you have is go back to school if you want to remain in the United States, look into CPT. Appeals and motions will not help you stay in the United States. It's a very commonly misunderstood fact that you are not allowed to stay in the United States just because you have filed an appeal or filed a motion to reopen. Your unlawful presence, maybe not in your case, but in many cases, begins to run and continues running. Okay, so you have to either go back to F1 or you have to apply for H1, whatever else is available. But definitely an MTR is not possible to, it's not a good device to stay in the United States. And if you file with the wrong fee, it's extremely likely that they are going to deny any MTR that you file. Okay, *5 if you have a follow-up question. *5. Okay, let's go on to the next question. Srinivas says, I was with company X on H-1B along with my dependents. They submitted H-1B withdrawal on Jan 5th. I started H-1B on March 8th. Also filed H-4. I'm planning to send my dependents. There's an RFE. I want to send my dependents to India. I don't see any problem with that. There's no risk. They see, even if they leave, all they'll have to do is, if and when your H1 is approved, they'll apply for an H4 visa based upon your H1 approval and come back into the United States. They don't need an H4 approval from USCIS. That's the difference between an H1 and an H4. For an H1, you first need a USCIS approval only, then you can get a visa. For H4, you do not need an H4 approval from USCIS. All you need is the H1 approval. Okay. Look into unlawful presence. Be very careful with that. I would be, because if the withdrawal was effected January, let's say January 5th, by June, you would be unlawfully present for 180 days unless your case is approved with an I-94. Watch out for that. Talk with your lawyers in detail. Make sure you have understood what unlawful presence is and how it could hurt you. Okay. I don't mean to alarm you, but this is something you want to be careful with. Good luck with that. Star 5, anybody? I'm sorry, not anybody. Srinivas, if you have a follow-up question, star 5. Okay, let's go to you. Go ahead, sir. Go ahead. Srinivas?
Hello?
Yes, sir, I can hear you. Go ahead.
Yeah, hi Rajeev. Just I want to know, actually now my H4 is in process, so at this point of time, can I send my dependents to India? Because unknowingly I have filed even H4 also along with
That's not a
H1B,
problem.
which is not.
See, if you leave while the H4 is pending, you just abandon the application. You don't need it if you're going for a visa stamping anyway.
Okay.
Not a big deal at all. Okay?
So it would not affect my H1B blocking, right? Because
No.
there is
No.
something.
No, it does not. But do check the unlawful presence issue with your lawyers, okay?
Okay. And I can do multiple H1B transfers, right? When one of my H1B is on query.
You can. You may have to
So
go
actually,
outside. You probably will have to go outside USA for visa stamping, but you can certainly apply.
Okay, that's fine. Okay.
All right. Good luck.
But I can go for multiple H1B transfers, right?
You
It's
can
not an issue, right?
file for 50 H1s if you want. No problem.
Sorry, your voice was speaking. Can you please
You
repeat?
can file for 50 H1s, 50 if you want. No problem.
Okay, right.
Good
Thank
luck,
you,
sir.
Rajeev.
You're welcome.
Thank
Bye-bye. Okay, this is actually, I was wrong. This GUI is effective if I know what to do. Maybe I don't know what I'm doing. Okay, good. Now I figured another thing out. What is the main advantage of special handling? Oh, this is a FAQ actually. I should have made this into a FAQ. Let me just convert it into a FAQ. Give me 1 second. So special handling is a special handling for professors. This is a very, very important thing to understand. Let me put a quote on this and okay. Special handling. You see, there are two main advantages to doing special handling. For people who are not aware of what special handling is, university, college, professors, teachers, they can use a special kind of PERM process called special handling. I could be a little bit off in the details, but the way it works is from the date the final job offer is made, if you apply for PERM within 18 months of that date, you don't have to re-advertise. So advantage number one, you can use the same recruitment that was used to hire you. Saves the university money. They like you. They have the budget for it. They've already advertised. Second very important benefit. In PERM, regular PERM, we have to prove that we have considered all minimally qualified candidates. In professors' special handling cases, we are allowed to hire the best qualified candidate. So when we do your case, we attach a letter explaining how out of the 25 candidates that were interviewed, you were the best qualified. So that's a very huge advantage. Those two things are big. Star 5 if you have a question on this. Star 5. Okay. U visa. By no means am I an expert in U visas. Can I apply for EAD concurrently? This I know. Normally, when they give you the U visa, they give you employment authorization with the approval. I think that's the way it works. How long does it take? My understanding, it should pretty much be simultaneous or follow. Not very clear about what the actual process is. We don't process U visas. If I get married after U visa, can my spouse get U immediately? I think so. I believe so. I don't believe there's any waiting there. Okay. Unfortunately, I don't have a whole lot of information more than what I just told you. But if you have any follow-up questions, I can try to answer them. Star 5. Star 5. By the way, so U visas are for victims of crime or people who are helping the federal government in prosecuting that crime. Well, not only the federal government, but law enforcement. Okay. So next question is PK3K7917. Working with company A, H-1B was good till September 1st. Extension was filed on July, so before it was expiring. I joined company B in September after my I-94 expired. So that means company B filed transfer on August 25th, which is before your current H-1B expired, because that expired on September 1st, and the company B filed H-1B transfer August 25th. They got the 7-9 approved from September 6th. Since extension was from company A was pending, you got an RFE. No action needed, because see, when your transfer was filed, it was filed within the life of your existing H1. But that was expiring in September, and the transfer was filed in August. So there's nothing you need to do. Okay. Or star 5 if you have any question on this. Star 5. Okay. This one is a difficult one to answer. TK2003 says, what happens to my 485 if my I-140 has been revoked because the old employer went out of business? 485 has been pending for over 8 years. But you filed AC21. Oof, this is a tough one to answer. I have never really analyzed this in detail. I know about automatic revocation when an employer ceases to do business. It is falling somewhere in the middle, where on the one extreme is revocation by USCIS for fraud or misrepresentation. On the other is a withdrawal by the employer of the I-140. In between is if they stop doing business. So I don't know how it's going to play out. What I would very strongly recommend is file a second green card through your current employer, just to be on the safe side. The new regulations should be able to protect you. AC21 is a very good argument, but don't take a chance on this. Go ahead and file a second PERM case. Anyone has, oh, not anyone. TK, if you have a question on this, star 5. Star 5. No question? Okay. RDS80 says, oh, good. They've used this forum through the green card journey, found it very useful. Got my green card last month after 10 years. Oh my God. Through a future-based green card application. I'm currently in a project that's good for my career. So I want to work on this, which is on L1B. Also, I've joined my green card sponsoring employer full-time. Is there any problem if I do 2 jobs? I'll get to you. I just saw your hand up. I'll get to you in 1 second. I'll get to you in 1 second. So can I do both jobs? I'll resign my present job as soon as the current project is over. I don't see any problem with that. Do I need to fill up revised I-9? Yes, you do. Yes, you do. You should let them know that you have a green card going. Okay, it's really the employer's responsibility. They're supposed to re-verify you, but when the green card is approved and they don't know about it, you should let them know and they can update your I-9. You can go ahead and put *5. If you have any question, I have already one hand raised. Oh, by the way, if you press *5 twice, your hand goes down. It's a toggle. So good you recognize that. Okay, so after that, I will do the new questions. Let me take this one call. Go ahead, please. You had a question?
Yes, Mr. Khanna. This is in the previous one, PK 2003.
Okay. Go ahead.
The 485 again was pending or filed concurrently with I-140 in 2007 fiasco.
Right.
And the revocation was due to the automatic employment out of the business.
Right. I got all of that. Yeah, I got all
fraudulent.
of that.
So, you know, the interesting.
Oh, hang on. Back up for a minute. Now, going out of business and fraudulent conduct are two different things. Was the employer put out of business by USCIS because they were committing fraud?
No. This was again a company closed with, you know, the financial crisis that happened in 2010, 2011.
Okay. All right. So, how can I help you?
So, 140 was revoked. This is like a month back.
Okay.
And 485 is still showing pending.
Okay.
We received our biometrics, but haven't heard anything since then.
Well, go ahead. Like I said, this is not a clear-cut yes or no answer. You have an argument to make. I'm protected by AC21. Go ahead and do your biometrics. Proceed as normal, but please start your second green card as well, just to be on the safe side. Okay?
Okay.
Good luck, sir.
Thank you.
You're welcome. Okay, folks, anybody has any questions, *5, please. Anybody has any question, new, old, very new, it all works. This is very unusual. So many people, only 2. Come on, going once, going twice, 3 questions, 3 people. Okay, well, that means it's a light day for me. Let's go for it. 4 people. Okay, all right. All right, Illinois, go ahead. Illinois.
Hello?
Yes, ma'am, I can hear you.
Hello, sir. I'm an international student and my F1 was rejected. It got cancelled. Then I reapplied for reinstatement, but that got rejected. And I'm still studying. What should I be doing for that?
Well, if your reinstatement is rejected, the only thing you can do is apply for a visa and see if you can get a visa to come back into the United States. Okay? If they give you an F1 visa, that's the only way to reset the clock. Make sure you explore with your DSO and your lawyers the issue of unlawful presence. Other than that, I have no problem.
Okay, thank you, sir.
You're welcome. Okay, let's go on to the next one. I see one more raised hand who just logged in. Guys, these are the last 4 people I'll be taking, no more after that. Okay, so let's go on to the next one. The same name, different people. Okay, Florida, go ahead. Florida.
Hello, sir. I have one question regarding the visitor visa converting to R1 visa.
Give me 1 second. Give me 1 second, sir. Guys, I will not be taking any more questions. I have 4 people in the queue. I will not be taking any more questions. So people who are just logging in, please log out. I will not be able to take any more questions. So, sir, you are asking me about conversion from tourist to religious visa. Go ahead.
Yeah, I actually called one of my cousin brothers from India on visitor visa. He was initially on Canada on some work visa, I think. And later on, when his Canada visa is going to expire, he's going to come back to US to visit my place, and he will stay here for 2-3 months and then go back to India. And what he was asking me that if he can convert his visitor visa into R1 visa.
I would not advise that, sir, because government can take that as a fraudulent entry and create all kinds of problems. It is theoretically possible, but if it were my own brother, my family, I would tell them, go to India, start the R1 in your absence, then get an R1 visa stamp and come back. Don't try to convert tourist visa to R1.
You mean to say he should go back to India?
India
and
or
then
Canada,
from there he should go for
yeah,
R1.
wherever, but not from USA, because government can consider that to be a misuse of tourist visa when you try to convert it to a long-term visa like R visa or student visa or L visa or H visa. So not a good idea.
Okay, and meanwhile, like my process was already under, my green card process is already under progress. So is it going to be having any implications, like if we want to convert that into R1?
No, as long as you are not doing any smuggling of aliens and people from other countries, the fact that he's your cousin and he happens to do something which government doesn't like, as long as you are not involved in any conspiracy, nothing to worry about.
Okay, all right. Thank you so much, and wish you a very happy Holi.
To Anuvi, thank you.
Thank you so much.
Bye bye. Yeah, I could see he's a Punjabi. I can't resist that. Okay, so let's go to the next one. Last three guys. Texas, go ahead, please.
Good afternoon, Rajesh sir.
Good afternoon, sir.
I am a sixth year H-1B,
Okay.
and I never been to India since 2010. I'm here. We are planning to go this July, and my sixth year will be completed by December 18th.
Okay.
So I'm planning to go without renewing my H1 because
Okay.
that's gonna take time. I can do only after June 18th.
Okay.
It's gonna take a month or two.
Right.
And I'm planning to go with my family, kids on summer vacation. So I'm
Okay.
planning to renew my H1 after I'm back from India. Is it a good idea or what do you suggest, sir?
Your current H1 is expiring December 18th. When are you re-entering the United States?
December 18, 2010.
No. Your current H1 is expiring on December 18th. When are you planning to leave and come back?
July 7th, leaving and coming on August 24th.
I don't see any problem.
That will have only 4 months of my.
Yeah, I actually,
right? So
this was a frequently asked question today. I just went into a whole detail of it. I don't see any problem. Listen to the recording, okay? I should have it up by Monday. Listen to the recording. This was discussed today as a frequently asked question. I think you should go ahead and buy your ticket. I don't see any problem.
Okay, sir. Thank you so much.
You're welcome. Okay, last two questions, guys. No, I'm not going to do any new questions. Put your hand down. No new questions. I already told you 7 times I said the same thing. I'm not doing any new questions. Please put your hand down. Just last two people who have logged in. Okay, this is my neighborhood, Washington, D.C. Go ahead, please.
Hi, yes. Thank you, Rajesh. I have a question. I've come here with my children. I am a U.S. citizen, actually.
Okay.
And I come in, my children have I-1, I guess. They came on an IR2 visa. Now, I'm having a lot of difficulty explaining when I go and apply for a passport for them. Nobody seems to understand what the IR2 visa is or what the I-551 process is, at least in the post office, which is where I thought I could apply. Can you suggest a place where I can, where people will actually understand what this is and be able to apply, or am I doing something wrong?
Hang on, let me try to understand this. I'm a little lost. You came to the United States as an immediate relative-based green card, correct? Hello? Oh no, I lost you. Okay, well, last question that I'm answering today, folks. Let's get that. This is Illinois. Illinois, go ahead, please.
Hello, sir. I am currently in H4 and I don't have surname in my passport. So
Ah,
I'm planning to apply for H1 to an employer system. So I want to know would it be a problem and what are the steps to include surname in my passport from
okay,
here in US?
okay. I think at one point I should do a frequently asked question on this. Guys, everybody who's logging in now, I will not be doing any new questions. Hate to waste your time. Don't just wait. I'm just answering the last question of the day now. So sorry about that. You guys need to be here earlier. I'm an old man, guys. Can't stay forever. Get tired after working a full day. Okay, so going back to you, ma'am, the change of name is in theory a simple process. As long as you can identify the person, whether they call themselves Sam, Tom, or John shouldn't be relevant because name change in the USA is a very simple process. You typically, depends upon the state to state, you typically go to the state, you pick up some papers at the court, local district court, or whatever that court is called. You fill those papers out. They tell you to advertise in the newspaper. Your name is changed. You can change that court order, changing formally your name. Sir, I'm not going to be able to take new questions. You need to hang up. I see the Washington, D.C. call. You are back again. I'll get to you. But that will be the last question I'll be answering. So please, all new people, I will not be able to take new questions. So, ma'am, going back to your issue, what happens is changing your name is real easy, okay? Formally changing it. Uh, but then comes the part where you have to change it on your social security number. You have to change it on your visa. Visa you can't change. You have to apply for a new visa. Eventually, when you go for a visa stamping, you can do that. Because if the court order contains your old name and your new name, you can use the same visa. At somewhere when it's about to expire, you can change it. Then you have to change it on any other documents you have. Okay, so it gets complicated. I will not be able to give you good advice without knowing all the details of your case. Instead of wasting money on hiring or consulting several lawyers, go back to your lawyers, talk with them, discuss with them. Hopefully they know what they are doing. Ask them what the process should be, whether this is a good time to change your name or during the green card process it should be changed. So there are several stages at which you can do it. Doesn't have to be done right away, but it can get complicated if the timing is not right. Theoretically, it's very simple, but logistically, it can be a little bit of a nightmare. Okay.
Okay. Okay,
So
but then I mean this with a passport without surname will not be a problem in H1B process, right?
we have tens of thousands of people. First name unknown, they put FNU. Last name unknown, LNU. So they do this all the time. I have a client whose three names, first, middle, last, they put all in one runaway name. And last name is unknown, first name is unknown, something like middle name they put in. So it becomes complicated. In his case, we are straightening out. But I can tell you this, it depends upon which stage you are. Theoretically, it's very simple. Get a court order, amend your document. But are you going to have problem with your Indian passport? I cannot predict that. Therefore, I said you need to talk with your lawyers before you decide which stage to do it. But the fact that you have it on your passport as first name unknown or last name unknown should not be a problem for your H1. Happens all the time. Okay?
Okay, thank you, sir.
You're welcome. Okay, last, very, very last call. Oh, sorry. Washington, D.C., back to you again. Washington, D.C.
I am sorry I lost you briefly.
No problem.
I'm,
I kept an eye out for you. Yeah, I kept an
I'm
eye
just trying to apply for a U.S. passport for my children.
Okay.
They have the I-551 stamp, and when I go to the post office to apply, they seem to be unclear about the
Okay.
process
Yeah.
of
Let's back you up.
IR visa.
Let's back you up a little bit. Did they get their? Hang on. The children were really young. You never got their green card, the actual document.
Sorry, the children were born in India, and they've been in my custody for several years. And this is the first time they're coming to the US, and this is the first opportunity they
Oh,
have to
okay.
come to the US.
Okay. Hang on. Let me back you up a little bit more. You are getting
Okay.
their passport based upon them being children of US citizen parents. Is that what you're doing?
Yes. So they have the immigration visa, IR2 visa, and now, based on whatever I've read, they are eligible to get the US passport.
Got it. Here is what you do. The simplest thing, cut through red tape. Just go to your local congressman's office. Okay? Call them up. Yeah?
Just go to them. Sorry, I'm not able to hear you.
Your congressman's office.
Okay.
You can go to www.congress.gov. There's a particular point there where you can say, find out who my congressman is. You put your zip code in there. It tells you this is your senator, this is your House of Representative member. You can call either one of them. Say, look, I'm a US citizen. I live in your neighborhood. I need help with an immigration case. Who should I talk with? They have 1, 2, even 3 staffers working on immigration cases. They love to help people because they expect you will vote for them. So you go ahead and ask them, I've got a problem, can you fix it? They can cut through all this nonsense red tape for you.
Okay, sounds good. Thank you so much for your help.
Anytime. Good luck.
Thank you.
All right, guys. Sorry, I know there are other people with their hands up. I can't do anything. I have to go. I have been saying it for a while that you should have put it up earlier. Anyhow, that said, great talking with you, and I'll see you again in 2 weeks. Thank you for your time, and thank you for being here.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.